everybody, welcome back to my channel. This is Ro. I have a video for you today that I should have made a year ago. So I've been updating. No, that's a lie. I have not been updating. I have been so bad at updating. But last April, yes, almost a year ago, it is March 2019. In April 2018, there was a case that was finally decided in the Supreme Court. So it came through the Supreme Court in 2016 maybe, and then they pushed it to the following session. So then oral arguments for that case was, I don't know, sometime in the fall of 2017, and then the decision, this date is so interesting to me, the decision was handed down on April 19th, 2018. Just keep that date in your head for a second. April 19th, 2018, okay? This case was called U.S. v. Demaya. I will put the playlist that I posted in every single day for about a week, because this case potentially could have gotten Adam relief. Well, Adam's still in jail a year later, so clearly it didn't work out the way that we had anticipated originally, but that doesn't mean that it's bad. So here, really quickly, that case was an immigration case. It relates to Adam because what was challenged in that case was the phrase, crime of violence. Because crime of violence to you might mean something different than it is to me. So this is called void for vagueness. That's what they challenged, saying that that part of the statute is void because the terminology violence, the word violence or crime of violence, is too vague. So the statute that Mr. Demaya's appeal questioned, that came out of my mouth funny, was a statute in the U.S. Constitution, which is known as 16B, which is parallel, written almost identically to 924C, the statute that Adam is sentenced under. So 16B says if an immigrant commits a crime of violence, we're going to attach this statute as an enhancement to their underlying crime. 924C says almost the same terminology, literally parallel, can be used interchangeably with each other. 924C says if a crime of violence is committed with a firearm, then we can attach this statute, 924C, to it. So when Demaya came down, we thought it was going to be like dominoes for 924C, because you could go back and appeal. Well, if 16B is void for vagueness, it doesn't matter anymore, it doesn't count anymore, then so should 924C be. So a couple people got out. They did the legal work quickly. Each district, unfortunately, because in the federal system, right, the United States is broken up into regions and districts. So each district started interpreting this and ruling on this differently. So this was kicked back to the Supreme Court, and there were a list of cases that were sent to the Supreme Court. This list was called the rewatch list, meaning the districts wanted clarification. How do we rule on this? What do we do? This case says this case says this. We don't know what to do. The Supreme Court came back. This was probably summer last year. I don't remember the exact date. Maybe like May, June of last year. They said, we're punting it back. Okay. This really bothered Adam so bad. He understands law so intricately. Never wants to become a lawyer, although my thought he very easily could, but I don't need him to be a lawyer. I want him to be whatever he wants to be. So anyway, but he's not like a lawman inside or anything, but what he knows, and he knows very well. So he said this all along. He's like, this is what's going to happen. The Supreme Court could very easily handle this and fix it because they know this is unjust. What they did instead was, he called it punted. They punted it back to the district courts and said, you guys get to decide. Well, what happened from there was exactly what I just said earlier. The second district or circuit said, I'm sorry, I'm botching. I always interchange district and circuit. I don't know what the difference is. But, well, I guess Adams I don't know what the difference is. But for sake of this video, I don't think it really matters all that much. But so the Second Circuit said, no, absolutely not. This does not qualify because the underlying crime is 100% violent, will always be violent. So, nope, we are rejecting the appeal. Meanwhile, people are getting out in the 10th Circuit, or I'm making this up. I think the 10th and the second both ruled against. Third is where Adam is. They've been sitting on that appeal, waiting for the Supreme Court to do something. It's been in, his appeal has been in for years, because we appealed before Demaya. We appealed for a case called U.S. versus Johnson that opened this void for vagueness door. Johnson was for the statute Armed Career Criminal Act, where they said that was void for vagueness. So we all jumped on it. We all got our appeals in because you needed to have them in by a certain date. Well, then Demaya came down. Now we're waiting again because all the districts are ruling differently in 924C. What happens in that case is it's a waiting game, and you have to wait for the Supreme Court to pick up a case. So when they pick up this case, they can set the precedent with this case, and so and that sets the precedent for what happens after that. So that's why I've been quiet, because we were just waiting for something to happen or nothing to happen. It's just a waiting game at this point. Finally, the Supreme Court picked up a case. It's U.S. versus Davis. This case will be heard, ready, oral arguments, ready that date I said earlier, April 19th, 2018. I thought the case was going to be heard, the oral arguments were going to be April 19th, 2019. Chills. I'm in the Target parking lot. I was in line. The lines were crazy long in Target because we're expecting a snowstorm, a lot of snow, starting in about an hour overnight tonight. So you can imagine everybody's out getting all the things they need. So I was in line, and I'm like, I knew I was going to make this video. I was like, let me just double check when exactly oral arguments are, and they're April 17th, 2019. So almost to the day that Demaya, the decision was handed down. And then, so the oral arguments are going to happen. We don't know, like, we'll get what do you call them? I think that you get the minutes, or whatever the legal version of minutes are. I'm telling you, I am not the one. So then Adam can he can read it. He does the legal stuff. He can kind of figure out what it looks like, but you never know. Then it's a waiting game until a decision is handed down. Remember, last time oral arguments were, I think, in the fall, and we didn't get a decision until April. I told him that this time, and he was like, I believe it's going to be faster. I believe we'll have a decision by like June, latest, by the end of the Supreme Court's term for the spring. I don't think they're going to kick it to next year or to next session. He said, because it's kind of black and white this time. And so I said, of course, now I'm like a little pessimistic. And I'm jaded. I'm not pessimistic. I'm cautiously optimistic. I'll say it like that, because I've just been on this roller coaster for so long. So if you go back to my video that I filmed on Christmas Eve about institutionalization and having to get off of this roller coaster, and how like the highs are so high for me and the lows are so low for me, and you're stuck on this legal roller coaster when you're stuck waiting for litigation and the Supreme Court and all this stuff and appeals, and you guys are pretty much all dealing with the legal system, so I don't even have to explain it to you. And if you're not, just know, whew, the wheels of justice spin slower than frozen molasses. So, where was I? Okay, so he thinks, so I was being cautiously optimistic, a little pessimistic when I said this one. I was like, my thought is, with Demaya, we thought it was going to be a landslide. Okay, we thought it was going to be 8-1, 9 justices. It wound up being pretty much split down the middle, 5-4 decision. Scary. So I said to him, I said, what happens if they got flack and those justices change their mind? Because all we need is for one person to vote in the other direction and we're screwed. And he said, typically that doesn't happen. He said, because, and he used some, again, legal terminology where they can't, like, you can't just change your opinion because of politics. You can't just change your opinion because you got flack for a different opinion. He said that's what the Supreme Court justices are for. They don't play politics. They don't play either side. They are 100% for what they feel is fair. And then so we have a couple of the justices who are constitutionalists. They are strict on what happened, like what the Constitution says, and if it's being applied properly. So we have that in our favor, where this law, 924C, is being misapplied. That was confirmed by the government in the First Step Act. Because in the First Step Act, the new bill that just passed, I believe it was December 4th or 9th, 2018, in December of 2019, it said that 924C cannot be stacked from this day moving forward. The day that the First Step Act was signed into law, from that day forward, you cannot charge 924C like that. However, it was not made retroactive. So the government basically said, yes, we're wrong, we're misapplying this law, and we're creating these crazy longer than life sentences for people who had a gun but didn't necessarily use it. They had a gun but nobody got hurt. Not saying that they don't deserve time, but we are not moving forward going to be able to stack them, because what this law was written to do, the 924C statute, was if you were arrested and you had a gun enhancement, you could get the 5 extra years if they charged you with 924C. You have to serve your time on that sentence and get out. Then the second or subsequent offense, okay, has to be a totally separate crime. It has to be that you got out, you served your time on your first 924C, you got out, you did it again, and then they charge you with that 25. Well, what started happening was prosecutors started stacking it and using it as a weapon for people to begin to cooperate. So they're saying second or subsequent could be like Adam, 9 robberies on the same, in the same 2 weeks, right? So they're charging him with all 9 robberies. So if you don't cooperate, we're going to give you 5 for the first, then we're going to give you 25 for the second, 25 for the third, 25 for the fourth, all the way up to the 9th. And so you're going to get this crazy longer than life sentence. Are you sure you don't want to cooperate? He said, no, I want to go to trial because I never thought in a million years I'd get a life sentence for this. I never thought in a million years they would charge me for that. Okay, are you sure? We want you to talk. We really don't think you should be going away for life for this. But if you don't talk, then you're leaving us no options. Really? No, I'm going to go to trial. I have the right to do so. And I really don't believe that it would be just to sentence me to life for 9 robberies. Yes, that was wrong. Yes, it was bad. Yes, 8 years for my underlying crime. Yes, 0 to 20 years even for the enhancements. The most amount of time that you can serve for Hobbs Act robbery, which is Adam's underlying crime, is 0 to 20 years. So to go outside of that is unjust. To pile these 924Cs on top of that is unjust. So that's what we're fighting. So we're waiting for April 17th for U.S. versus Davis for oral arguments. So I do apologize. I haven't updated because I haven't had anything to update. But then one of my sweet subscribers commented on the video that I made back in April and was like, hey, what's the update with this? You just kind of fell off the face. Because I did. I was updating every day for 7 days and then it just kind of fell off the face. Because they roadblocked us, basically, for a while. So, that's it. I will continue to update as I know more. Thank you, sweetheart, who posted under there, because it did prompt me to come in and make this video and explain it to you guys, because, hello, that's what I'm here for. That's what I do. I explain all of this stuff to you because you guys are my besties now. So, prayers, positive thoughts. He thinks it has a good outlook. Personally, cautiously optimistic. And I could tell you how things just kind of change as you go through this more and as you develop scar tissue, basically, from all of the ups and downs and the hurts that this causes. So with Demaya, I would every single day check the docket. I would have Google alerts set up. I would wait every single day, and every single day between whatever it was, October, let's say, somewhere in the fall, up until April, every day I was checking, every day I was checking, every day I was checking, and I was getting depressed that there was no answer, blah, blah, blah. Oh my God, it's taking too long. It's going to be unfavorable. And then one day, I get this text message from my dear friend Marie in Ireland, and she's like, oh my God, Demaya was decided. Ireland. United States had no idea what was going on in my Supreme Court, but she's a dear friend. She gets the U.S. news, and she is always the first to keep me posted on these things. And I was like, what? And then I got the Google alert within minutes. It was positive. This was like right before my lunch break that day. I was at work. It was a weekday. And I called Devon, my dear friend Devon, who runs Mercy Me 924C, because her husband is serving like 150 years or something. Like after what? After 30 years, it's all the same anyway. So we were on the phone, Adam beeped in, and he was, go back and watch that video, because I say it in real time. I was like crying, he's coming home. Well, little did I know, he is coming home. He will come home eventually, but, you know, it was just wanted my biological clock to just tick a little faster. I was telling my friend today, I was joking, I was like, my biological clock is in like the 11th, not the 11th hour, it's like 11 and 45 minutes. It is 11:55 on my biological clock, because we were joking that one of our other friends, her son is getting deployed to Okinawa, and our mutual friend was, these are SPWF sisters, by the way. I'm just not using their names because I don't know if they want them to be used. Excuse me. I should not be wiping my nose with my fingers on a video. That's disgusting. I'm sorry. I should probably edit that out. But, so she goes, Okinawa, she's military in her family, her husband's military, and she goes, that's where you go and you come back with 2 babies, not 1 baby. She goes, like, everybody there has twins. So I was like, oh, I know what I'm going to do. Honeymoon with Mr. Clausen in Okinawa, because I got 1 shot, hopefully, if we can get this resolved within 5 minutes, because my biological clock is ticking 11:55 at this point. You just gotta laugh. I just joke about these things because what are our alternatives? So I'll keep you guys posted. I will be back way before April, but that's the update right now. As I get more updates with Davis or anything else that comes through with Adam's case or the Supreme Court or anything else that could potentially help us, there are a few avenues open right now. Most of them are moonshots, but that's okay. I mean, aim for the moon, they say you hit the stars and you're still successful. So let's see what happens with that. But this is probably the most concrete. You know, we're aiming for clemency again, but that's another moonshot. President Trump hasn't done any clemencies for a really, really long time. So that's where we are right now. We're remaining hopeful, we're cautiously optimistic, and I will keep updating as I know more. You guys keep staying strong, keep loving strong, keep supporting one another through this journey, because we're one day closer to it all being behind you. Lots of love from my heart to yours. I will see you beautiful ladies and gentlemen in the next one, but in the meantime, just make sure that you're holding on to hope, that you are cautiously optimistic, that you're not getting too caught up in these legal roller coasters, because it is, from somebody who's been living this for a really long time, grueling. So you just stay strong, and I will see you in the next one.